Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Hi, I want to welcome back Shalini Nanjia and Carrie Rosenblum. We had a wonderful discussion before, and we are going to have another one since it was so popular. But it is so specific that I am going to let Carrie do the introduction, and I have a feeling that I am going to be more a fly on the wall and let you two just go do your thing, and I'll interrupt on occasion. But welcome, both of you.
Thank you.
Thanks, Carrie.
We are a little hard to contain, but we will do our best. So as Shalini and I reflected on our last discussion with you, Carrie, we sort of thought about what is the largest sort of issue that we see collectively as a therapist and for Shalini as a lawyer that we might want to address. And what we really thought about was sort of the anxiety around just the whole divorce process in general. You have these two mandates to determine how you'll parent and how you will divide your debts and assets and have a financial arrangement going forward. And today we thought that whole anxiety around parenting and custody is something that really comes up a lot. And it's oftentimes the reason why people don't make the decision to divorce, or the reason why the decision to divorce is so worrisome is what's going to happen with my kids and my right to parent them. And so we talked a little bit last time about the 12 factors that the court uses to determine their sense of the balance of custody. And I think rather than maybe kind of go through them all, they're easily accessible. You can Google sort of the 12 factors in whatever jurisdiction you're in. That's what the judge uses. And today we thought we would talk about sort of from the legal side, what a judge looks at, what the resources are available for the judge to use to expand their range of knowledge. And then when the decision comes down, the range of decisions and how you live with it. So it's kind of tying together, as we like to do, the legal and the emotional side of divorce. So I will ask Shalini to kind of talk about the legal side of those factors and what a judge is going to do about them.
Well, as you mentioned, there's 12 best interest factors, and they are the same throughout Michigan. So if somebody were to be Googling them, you can, Google best interest factors. Be sure to include the word Michigan, because I imagine other states may have similar ones, but, Michigan has their own specific 12 best interest factors. And so whatever stage you're at, like, in your divorce case, whether you're at the front of the court or whether you're like in court at a trial with the judge, these are the best interest factors that are kind of used. And I often will send my clients the best interest factors so that they have a sense of, okay, what are we looking for? And, it's a fairly comprehensive list, but at the same time, like, you can go through those factors and you can talk about each one, but it's still tricky as to like, okay, well, what does that mean as to like, what's my parenting time going to look like? And what's like custody going to look like? And it's really tough because when a court evaluates the best interest factors, like they will literally, they'll have the discussion, like if you're doing this in writing, and they'll say mother wins this factor, father wins this factor. And so then you like add it all up and it's like, oh, okay, one parent has 7 and the other one has 5 in their favor. Yay, I win. or maybe you think you win, but like, what are you winning? And like, how is the determination of these factors actually going to give you what your schedule looks like, right? And if a parent is quote unquote winning on the factors, what does that mean? Because at the end of the day, the court is looking obviously for the best interests of the children, but when it comes to parenting, you may have a parent who thinks they're the better parent. maybe they are in some respects than the other parent, but at the end of the day, the court's not looking for a good parent. They're looking for a parent to be good enough, right? And so that might be a difficult pill to swallow for some people, because they're like, well, wait a minute, there's all these deficiencies and look at all these factors that I won on. So this is why it's like gets a little bit tricky. And this whole what does the parenting time look like? Well, that is still something that can be a struggle to determine. But when I'm preparing clients, I always tell them, like, it's all factual. So when you send them the best interest factors and it talks about, like, for example, which client is better, or, which parent is able to provide food, clothing, and shelter, for example. It's like, you have to be like factual about it, right? You have to actually give all these details about your kids and what happens in your household, and every fact can matter. So when you're talking to a client, you want to make sure that they like think about every fact. The other thing to keep in mind is that different judges can weigh these factors differently. Like, you have to look at all 12, but one judge may put a lot of importance on one factor, and another judge may completely overlook that. For example, the child's preference is one of the best interest factors. Well, what does the child's preference mean? To some judges, maybe it's very important. And one thing that could be relevant is, how old is the child? Because if your kid is, 5, maybe that factor doesn't really even get looked at, right? I mean, is a 5-year-old able to like really express a cogent opinion on this? Whereas if you have a 16-year-old, maybe that's even more relevant.
Can I ask you a question, Shalini?
Sure.
Just to kind of go back to something. When you
Sure.
said it's all factual, as a lawyer, that means something to you different from a layperson, because I run into a lot of times where the judge didn't listen to me. I told them what my child said. My child told me that the other parent sent him outside to play in the snow without boots and a coat, and the judge didn't care and still said they provide food, clothing, and shelter. That to a client is a fact. Their kid said that. They came home they were shivering. They were, that legally is not a fact. So,
well, and that does get tricky, because most of the information we hear from a parent is what they heard from their child, right? And that gets very frustrating, because when we're looking at evidence like that, which a court would actually take in a trial situation, there's a concept called hearsay, which is what somebody else told you is not necessarily admissible in court. There's some exceptions. And so depending on what information we're talking about, maybe it's admissible. But for the most part, your garden variety, well, this happened at dad's, or that happened at dad's or mom's. I mean, like, yeah, you may not be able to get that into evidence. So when a client comes to you with all this great information, you do sometimes struggle, because it's like, well, that's true, but like, how do we get this in front of the judge? Now, keep in mind, these best interest factors, like I said, at the beginning of your case, you may just be talking to a friend of the court worker who's also analyzing the factors and making a recommendation in your case. They can hear everything. So they can hear the hearsay. They can, look at your text messages. If you have your child's phone and there's a bunch of text messages with the other parent, that could all be something the friend of the court looks at. But that's a different situation than if we're preparing for trial, when certain things may not be admissible. And at the end of the day, if a child said something, the best way to get that into evidence would be to have the child testify. But of course, I mean, in 30 years of practice, I've never had a case where I've put a child on the stand. And I would say most attorneys don't think that's a great idea to put your kids on the stand.
Do you usually, before trial, have some interaction with friend of the court? Or like, is that judge mandated, or is that client or attorney request? How do you get that friend of the court? How do you get the information to friend of the court to bolster sort of your lack of legal evidence? And then what weight does that friend of the court have on the outcome?
I mean, at the start of the case, if you and your spouse have like pretty, decent agreements as to how you want to handle parenting time, then you may never see friend of the court, right? Because you're just going to have your agreements, and that's what you're going to put into writing, and you're going to go on your merry way. How it usually comes up is there's a disagreement. One parent wants, one schedule, and the other parent wants another one. And so it can come up in two ways. early on in the case, when the attorneys meet with the court for like a pretrial conference, you could say like, hey, I think custody and parenting time are going to be a problem in this case. And so the court may just say, okay, I'll refer it to friend of the court for like an evaluation. So that's probably the easiest. Or maybe you're at mediation, and you're, talking through these issues, and it's apparent that, hey, custody and parenting time are going to be a problem. And so the parties may say, why don't we, ask for a referral to the front of the court for an evaluation? And the idea being that maybe if someone from the court, and keep in mind, when an evaluator at the front of the court is talking to you, they're usually a social worker. So it's not an attorney, it's not a judge, it's somebody that's meeting with the parents. They could potentially talk to third parties like grandparents or teachers, doctors. I mean, if doctors have time to talk, whatever, some person who you think has some really relevant information, a nanny, about the care of your children. The friend of the court worker may talk to all of those people, and they can also interview your children. And then they write up this recommendation, and the recommendation will talk about, this is what mom told me, this is what dad told me. If they interview the child, they don't disclose what the child said, but that is a part of what their recommendation and their analysis of the best interest factors, they will take that into account. And then they issue this report. Now, again, it's just a recommendation. And I think the idea behind it was, oh, maybe if maybe if the parents read this, they will think, oh, maybe it will push them in towards settlement. Sometimes that happens, but I would say the reality of it is, because either side can object to it, sometimes that's what one side is doing. Because if they're really determined, like, I want what I want, they may file an objection, and it's just kind of one more path down towards perhaps going to a trial, perhaps having more mediation to have more discussions about this. So it can be a useful settlement tool sometimes. And it's certainly, if there's something in there that the evaluator has noted, your attorney's going to certainly point to that and say, well, look, the evaluator said, this, and this about the facts, or about the best interest factors. So that's how it kind of comes up at the front of the court.
Like you go into, like, you have this anxiety and you're thinking like, I can't get divorced, or if I get divorced, I can't relinquish my kids to this terrible other parent. And the fact is, unless, there's terrible and then there's the feeling of terrible, actually terrible is a whole different thing. The worry and the concern and the fear about the other parent who maybe hasn't been very involved, doesn't have great skills, all of those things that we hear that people are worried about. At the end of the day, very rarely is somebody not going to have parenting time. So let's say you go through the whole process, and maybe the win for the parent who feels like the preferred parent is 70-30. There's still 30% of the child's life that is going to be with somebody who feels that it's not safe emotionally, physically, in whatever way for the child. Taking out, sort of parental anxiety around this idea of like, I don't want to lose my kids for that amount of time. Then what, right? Like, so now you've gone through the whole process in front of the court, the evaluator, the judge, the 12 best interest factors, and they say, okay, other parent has, 30%. What do you, like, I know, like, therapeutically how I try to manage that. And I can talk about that, but I wonder what the legal options are for sort of putting some safeguards in place when you feel like, even though you won, you lost. The kid's lost.
Well, I mean, and some of that is just a parent kind of coming to terms with the fact that, hey, this is the person you married and had kids with. And so, like, you're going to have to, like, figure out some way, right? I mean, we have different tools depending on what the issues are. You may have, there's programs out there, like communication programs, like Our Family Wizard, right? Which have like a communication aspect. They have a reimbursement of fees aspect. They have a calendar, right? A shared calendar, because a lot of times people who are getting divorced don't communicate well together. So maybe it's just, if you could have some assistance in communication with the other side, it would be more smooth, right? Or if you have a situation where, 30% is like, it's still bad, or if you still feel like the child's needs aren't being met, how do we voice that? How do we address that? We try to use different tools. I mean, one tool we try to utilize is your services as a co-parenting therapist, right? Because at the end of the day, the court is not going to spend the time, doesn't have the time, frankly, to sit there and listen to the fine details of why parenting time isn't going well, right?
No nuance in court, yeah.
The nuance, right? Because sure, if a child is being physically abused, that's a little bit more straightforward, and there's probably like easy evidence that you can bring forth, right? Maybe there's a criminal case going on, maybe there's bruises, or there's something that you can bring to the court's attention to say, this is why this isn't working. Maybe you have a situation where during the 30% of the time that the parent has the child, the kid's never getting to school, or the kid's never, you can document that the kid's homework is never getting done. Those are kind of easier cases to maybe bring to the court's attention. But where the trouble is where you have kids who are like really resistant to going, right? And you get clients all the time. The kid refuses to go. What can I do? The kid refuses to go. So in a way, that's easy, right? But it's not, because why is it? The question is, why is the kid not going? And that's where like a therapist or someone like you kind of steps in and takes a look at it. And people in your role could be a co-parenting therapist. You could be a family therapist. We could appoint like a guardian ad litem to like really dig into this a little bit more, talk to the parties, talk to the therapists, if the kid has a therapist, or if mom has a therapist, or dad has a therapist, like what are the underlying reasons why things are not working?
I mean, my favorite combination is like when I'm working as a co-parenting therapist, or reunification, which is a whole different thing I can't even tackle right now, because that's a beast of its own that I'm really trying hard to create some sort of protocol for that actually works. But so staying with co-parenting therapy, I love the combination of a co-parenting therapist and a guardian ad litem, because a co-parenting therapist can do the work in the privacy of therapy and really allow people to communicate things that they don't want to share on a public record. And then I can sort of synthesize that information and work collaboratively with the guardian ad litem to say, here's what might benefit this family.
Well, can you tell, and I can tell them, but like what role does a guardian ad litem play in this?
Well, I mean, I'll leave that to you, Shalini. That's a good legal question.
Well, a guardian ad litem is somebody who is typically an attorney, but that is someone who the court will appoint to kind of act in the child's best interest, because a judge, has mom coming in saying all this stuff and has dad coming in and saying, another scenario. And so the court's like, all right, how do I suss through this? Like, how do I know what's actually going on? So they may appoint a guardian ad litem who is then tasked, similarly to what the friend of the court is doing. But now you have someone who is basically, again, an attorney who has the authority to go interview all these people, like I said, doctors, therapists, and the parents are usually required to, sign waivers to allow this guardian ad litem to talk to everyone. And then that person is in the role of kind of synthesizing information and providing a report. And within this report, again, there could be recommendations. And oftentimes the parties will agree when a guardian ad litem is appointed that if the GAL makes a recommendation, it's going to be treated as a court order until someone objects. So, I mean, ultimately the judge is the one who has the final say. But for families who are like really struggling with decisions on what extracurriculars activities, like we don't disagree, we don't agree on these things, or, hey, I really want to take this vacation, and like, well, I'm kind of mixing up GAL and parenting coordinator a little bit, but these are both roles. I mean, they're both basically someone in the middle who can help to resolve things between parents who are not agreeing. There are some distinctions between a parenting coordinator and a GAL, but in essence, they are both people who are kind of appointed by the court, who have some like interim decision-making ability when parents need some help. The GAL is probably a little bit more broad in terms of making maybe a general recommendation to the court, whereas the parenting coordinator is kind of the kind of on-call referee to decide, like, should Johnny go to, be signed up for soccer or not? Or, hey, I want to take this vacation, but the other side's not agreeing to my dates, and you just need someone to kind of step in. Sorry, Carrie, you.
No problem. Now
I have a
question. you said the GAL could talk to doctors and school and whatnot. Does the parent coordinator typically reach out to all those people also, or is that more a one-on-one?
That's why I kind of sometimes accidentally use them interchangeably, because the parenting coordinator will also have the authority. Usually when we appoint a parenting coordinator, the order appointing them also says that the parents will give permission for this parenting coordinator to talk to therapists and doctors. Basically, they have kind of wide breadth to talk to anyone who's relevant. And so, yes, they too may talk to third persons who they feel have some important information to share about the children.
So why would one be picked over another one?
Why would one person, parenting coordinator, be picked over another one?
No, a parenting coordinator, a GAL, like who decides? What's the difference?
So the interesting thing is that a GAL is, a court can appoint one whether you're asking for it or not. Like if the judge has all this conflicting information from both sides and says, I really need to get to the bottom of this, I'm going to appoint a GAL. Even if one parent is objecting, too bad, too sad. The judge is doing it, right?
Okay. And
a
they would
parenting
never
coordinator
do that to a parenting coordinator. They would never.
A parenting coordinator needs to be agreed upon by the parents. So some cases I wish I could have a parenting coordinator, but one parent or maybe both are not okay with it. The other distinction is usually a GAL appointment is fairly open-ended. So if a GAL is appointed, like they could be on the case until there's an order dismissing them. Whereas a parenting coordinator is typically going to have some sort of like agreement to a term, either a 1 year, 2 year. I suppose you could agree to whatever term you want, but it could be a more short-lived situation.
My favorite combination is like, because GALs and PCs are often lawyers, is being the co-parenting therapist in conjunction with the GAL and PC, because then you have both the emotional and the legal side of, you know, what needs to happen in this family, and then how do we make it happen?
Yeah.
And I'll tell you, Carrie, that like I've worked with GALs who will spend time in the parent's home. They'll take the kids for ice cream. They'll play soccer. They'll really, really sort of infiltrate to see what's going on. And it's really spectacular information for me, who's sitting in an office, you know, an hour or so every week or 2 weeks or so, saying, okay, here you are at your worst. Let's talk about it. So the combination is really amazing, because at the end of the day, at some point, there is going to be an agreement that this family has to live with. And the problem is, and this is kind of where I enter the fray, is that if parents can't live with it, kids can't. There's, you know, if the kids are constantly sort of like when you talk, Shalini, about the resistant kids, if kids constantly feel like they have the power to change the schedule or to advocate for a schedule change or to resist in order to get a schedule change, or there's still some flux, they'll play that card. That's how they survive. They're advocates. They will do what they can. Even if it's difficult, even if it's unfair, even if there is a parent who is just good enough, which obviously isn't the standard we want, but that's the standard that there is, it's so important that early on services are provided to parents, to children, to say, this is what you have to deal with. And it might be hard and it might not be fair, but the constant fighting and the constant upheaval is harder and less fair. And so sometimes somebody kind of has to come in and be the heavy and say, we're not going to talk about what should happen. We now have to pivot to talking about how do you survive it.
Right.
And that's really hard, because it's really hard to get one parent to agree to relinquish control to a situation that doesn't serve the needs of their children according to that parent, and live with it. And the fact is, data, research, experience is that the absence of conflict and the presence of certainty is much more tolerable to kids than a good enough parent, right? I mean, than fighting against a good enough parent. And so it's this fine line where, you know, the guardian ad litem does a great job of collecting data to make sure there's nothing like particularly nefarious or really, really intolerable going on. And if that's the case, then I'm the person who can really say, we got to learn to live with this. And these are the tools you need. And this is what you need to do, parent one, to support the children going to parent two, and parent two, if you're open to it, this is what you need to do to be a little bit better. And so my feeling is the earlier you can get to that point, the sooner in the process you can get to that point of saying, this is what we have to live with, the better the outcome is for the kids. Because I think also, like, you know, for you, Shalini, as a lawyer, you are an advocate for one person. And even though, as the good lawyer that you are, you tend to see the bigger picture and you are family centric, which is why I love working with you, you are hired to be an advocate for your client. Whether you like what you're advocating for or not, that is your job. I have the benefit and sometimes the burden of being able to be the advocate for the children, which puts me in a neutral place for both parents to say, look, like, this is what you have to do. This is what your kids need. This is what your kids require. And then beg the attorneys and the GAL and everybody else to sort of support that. And so it really does take a team. When there is a custody conflict, it takes a team. There is no win until the children are stabilized and able to go back and forth from home to home, cross the bridge in between without conflict, without tension, without anxiety, without fear. That's the win, right? So that's my finish line, which often exceeds the jurisdiction of the court's finish line, which makes it kind of hard.
At the end of the day, like, absent somebody being like a pedophile or something, the other parent is always going to get parenting time. So whether that parenting time is 10%, 20%, 30%, 40%, like, you still have to deal with it on some level, right? And so it becomes like, and that's really tough too, right? When you're arguing in court, because a parent, you know, you have one parent comes in, I want 50-50, I want 50-50. And their motivation for wanting 50-50 could be various reasons, but like, if that's what they want, and then I have my client who's like, I'll take anything less than 50-50. How do you argue to the court, like, okay, well, they're good enough to have 30%, but they're just not good enough to have 50%, right? And that's where I need some help in trying to explain to the judge why that 20%, that little like difference, actually is important for the kid. Like, why does it make a difference to the child, not to my client so much? Why is it important that the child have this much less time? And sometimes, you know, it's easy enough. Like, if one parent lives far away and, you know, the commute to school is really difficult, like, well, judge, a 50-50 schedule doesn't make any sense because the parent lives so far away and the kid's in the car for 2 hours a day. And so you could have easier explanations such as that. But like, if it's just that the other parent is not in tune to the kid's needs or just isn't like used to being the primary caregiver for the parent, those are tougher arguments to win in court, because the judges, I think, are inclined to give parents a chance. Oh, like that parent can learn those things. And maybe they can and maybe they can't, right? And maybe with the help of someone like Carrie, they can learn. Or maybe you send that parent to a child development specialist, or you send them to a parenting class. I don't know. Maybe they can learn. But I would venture to say most parents aren't readily like willing to say, you're right, I'm not really sure how to parent my kids. I do need to go to a class. Let me do that. So those are tough. Like, those are the tougher situations where a parent is like, sure, the kid's not going to die and the kid's going to be fed. Maybe the kid is fed pizza every day and not like vegetables and baked chicken or whatever, but the court's not going to really ding a parent for not doing the best that they can.
You're right.
They're good enough.
Good enough.
Good enough. And you have, obviously, I know you two, you could talk forever, and there's so many spider webs that we can go off on. And maybe you'll agree to come back for a third time, but you brought up a really good point that I'm sitting here thinking, I hear so many people say, I am going to wait for the kids to turn 18, so I don't have to do all these things. And my personal opinion is I think it's better to do them when they're younger, so you can work out all this stuff when you have the court system behind you to make sure it happens, than opposed to waiting till they're 18 and then you're kind of winging it.
We can.
Oh yeah, I have a lot of thoughts on that too.
Me too. I have so many thoughts on the illusion that later is better.
All right, well, good. Well, then can I have you guys come back and we'll do another one?
Of course.
Of course.
All right, thank you so much. You always enlightened me, and I'm sure everybody else, so much. And it's such an important topic. There's like endless possibilities, right? So I really appreciate both of you sharing your thoughts and making people aware that there's a lot to think about and to resolve, and they're not uncommon if they think their family is, alone and doing all this.
And if I could just throw in one kind of last disclaimer, there's a lot we've talked about. There's a lot of like suggestions and things that have been thrown out. But what I would caution anyone is, as I mentioned at the start of this, your facts matter. So if you have someone who's talking to their friend or their neighbor and it's like, oh, well, in their case, X, Y, and Z happened. And
good point.
It's very difficult because again, every fact matters. And so what happened in your neighbor's case may not necessarily mirror what could happen in yours, because your kids are different, your judge may be different, your county may be different. So I just caution people, and even as to anything Carrie and I have said today, depending on the facts of your case, it could be something very different.
That was a very, very good point. And there are a lot of people that have outside opinions that probably cause more problems than good. So if anyone wants to get a hold of either one of you, Shalini, go first. What's the best way to get a hold of you?
Well, you can send me an email. My email address is S as in Sam, H, N as in Nancy, ANGIA @varnumlaw.com. And that's one word, V as in Victor, ARNUM law.com, SH Nanjia @varnumlaw.com. My phone number is 734-372-2928.
Wonderful. And Carrie?
I can be reached at Carrie at Divorce Beyond Court, and Carrie is CARRIE at Divorce Beyond Court, spelled the way you would expect it to be spelled. And then I can give you my website and you can go, it's divorcebeyondcourt.com. All the other information you need is on there.
Wonderful.
But here's my little final note is, if you're thinking about divorce, gather your resources early so that you go in empowered, educated, resourced, and ready to understand what your children need, because that is going to be very different from what you need. And the children are really the people that everybody's looking out for in these situations.
Good point also. You guys are great. Thank you.
Thank you.
Thanks, ladies.
I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.